counts as an employee in an ever-changing economy that is increasingly reliant on contract and temporary workers? Well, in a recent 3-2 decision, the National Labor Relations Board has cleared the way for unions to negotiate on behalf of workers at fast food chains and other companies that utilize contractors and franchisees, according to the Wall Street Journal. The case the Federal Labor Board ruled on involved Browning-Ferris Industries of California, a company which the NLRB found to be a joint employer with Lead Point Business Services, a staffing agency hired to provide workers for one of the company's recycling plants. Historically, the Federal Labor Board has considered a company to be a joint employer if it exercises, quote, direct and immediate control over employees, according to the decision. Many business groups have called on a Republican-controlled Congress to overturn the ruling, arguing the decision will lead to unstable bargaining relationships. I'm joined today by attorney Michael Scimone, an associate at Outten and Golden, who represents employees in class and collective actions, focusing mainly on wage and hour litigation. Michael, what do you make of the National Labor Relations Board's recent decision to expand the definition of the joint employer standard?
Well, this ruling is a big step forward for workers, especially for the growing sectors of the workforce that are engaged in temporary or contingent work. And we're talking there about a significant number of people. Currently, about 5.7 million workers are in contingent employment situations. That's about 4.1% of all employment in the country. And temporary work is about doubled from 1990 to 2008. So there are a lot of people potentially affected by this. What it means is that collective bargaining and organizing a union is something that's going to be potentially much more meaningful for people in those kinds of working situations. More meaningful because the companies that ultimately have control over their wages and their working conditions will potentially have to be at the table. Without those prime contractors involved in the negotiation, there's very little that can actually be accomplished in collective bargaining in a lot of situations.
And how might the new joint employer standard affect non-union entities?
Well, non-union entities always have the potential to become union entities. So what it means is that if you're currently working in a non-union environment, the odds of being able to organize a union become much better. Non-union companies are now going to have to take account when they enter into contracting relationships or subcontracting relationships of the employment conditions and the working conditions that exist, and understand that they may ultimately have to negotiate with the union or with the people that they're employing. It also has an effect in situations where there is organizing going on, because the joint employer, the prime contractor, can in some cases be held liable for committing unfair labor practices. And so if the joint employer, if the prime contracting company does something to interfere with organizing activity by employees or tries to fire people who are engaged in organizing a union, they can potentially be held liable for that. And that means not only that bargaining will be more meaningful if it does actually come to fruition, but also that the process of organizing will be much fairer.
Finally, in related news, President Obama recently signed an executive order that mandates paid sick leave for federal contractor employees. Michael, for businesses that can't afford the new benefit, do you think there will be any legal implications?
So, this is, I think this illustrates, why it is that, a decision like the Browning-Ferris case from the NLRB is not the catastrophe that most employers make it out to be. There are lots of requirements that, contracting entities impose on their subcontractors already, and the federal government imposes a number as well. Companies that do business with the government find ways to make that work, and if they didn't, then they wouldn't be in that business. Ultimately, most of the firms that are contracting with the federal government are going to be able to comply with the law, and this won't have a major impact, ultimately, I think, on the bottom line. There are lots of studies, of course, that show that providing paid sick leave is actually much more efficient than allowing sick people to come to work and potentially infect other workers and decrease productivity. So there's certainly a business case to be made for that. New York City has a paid sick leave law in effect currently, and there are similar bills that are being pursued in other municipalities around the country. This is really, the way forward, I think, and a big change that we're going to see in a much wider context.
Thank you for speaking with us, Michael.
Thank you very much.
That was Outten and Golden attorney Michael Scimone. We'll continue to keep you informed as we follow the changing landscape of employee and employer rights. I'm Emily Collins for Employment Law Channel.